Section 49, which is now in the Act, also talks about other sources of funding being to shift the current tax credit to medical schemes to be shifted to the fund. And then the 8.4 to 8.6 are proposes as sources of funding which Parliament considered and approved the bill on the basis of that set out on financial implications. What Dr. Armstrong does is to say that what you really need to calculate is what the actual project of NHI is going to cost the state, is going to cost. And she calculates that difference at paragraph 164 in her report, 003-333, she calculates that for each year, you're going to have a significant shortfall between what NHI requires and what is currently spent on healthcare. And so in Roman 1, she says for 2025-26, you will have in 2022-2023 terms, you will have a shortfall of 472 billion. That would require the government healthcare expenditure in 2024-25, which will be 242 billion in 2022-23 terms, grows by 95% to cover the increased costs because of NHI. So that's how she does. She calculates the full cost of NHI and says, per year, what is the shortfall between what you're currently spending on healthcare and what NHI will cost. And then she says, because you need to raise money to cover that shortfall in order to afford NHI, you're going to have to increase taxes. And she discusses different funding models on taxpayers. You'll see that from 003-336 and following. But all she can do is discuss what potential taxes may be raised and the levels of taxes that may be raised. She can't say, just like the department say in advance, what specific taxes will be necessary to be raised at the time when you do have a shortfall. Because in the beginning stages of implementation, you're only rolling out steps. You're not yet at the point where you have this full shortfall that she calculates at paragraph 164. Well, yes, in fact, in some of the responses in the meeting of the 30th of November 2022, it's in the annexures AA17, it says 004-979. That's a department's response. Recall you had that thematic report by the portfolio committee summarizing all the input from the public participation process, and in paragraph 6 saying we are going to hold a meeting of the portfolio committee to consider all of these comments. I'm reminded that report summarizes input up to about February 2022. But they say in that report they're going to have a subsequent meeting of the portfolio committee to consider all of that input. Now, the way in which Parliament, the portfolio committee for the National Assembly and the Standing Committee for the NCOP responded to public comments was to seek the assistance of the department. Say, we have a summary of the comments from the public, what is your response to them? And then hold a meeting, public meeting, at which they consider the concern and the response of the department and take a view. But recall that the portfolio committee comprises opposition parties as well, so they have differences of view in the debate, but ultimately the view that prevails will be the view of the majority as to whether the legislation will be adopted despite the concerns and the responses. So AA17 is the department's responses to that report of the portfolio committee summarizing the public comments. And then the meeting report itself of 30th November is AA16, and you will find that it's 004-967. And that will record the interaction between the portfolio committee and the department, going through the concerns and getting what is the department's response, is the committee satisfied with those responses in order to make a final decision. So in that response, they also discuss in that presentation of the department, just said is AA17 at 004-979. At 004-1043, you will see the department's response on funding, discussing the various options for raising any funding to fund NHI.
Mr. Maneji, are you saying, and I'm just struggling to get on page lines, that document, the paragraph 8 that you've referred to in the memorandum?
Yes.
Perhaps your colleagues can just direct me page lines.
Yes, I can give the quote that is at 00, the relevant paragraph is 003-843. So it's part of the memorandum accompanying the bill.
Yes. Are you saying that, I know you say that accords with WHO guidelines, where your projections are uncertain and unreliable because you have such a long time span for implementation, 20 plus years, and obviously the figures will be unreliable. Are you saying those 8 steps are adequate for purposes of information to those who want to interrogate the costing of this new model?
So this would be sufficient for purposes of understanding the initial steps that are intended to be implemented. But if somebody like PHF wanted to understand a different number, which is the full cost, then they have, as a starting point, they would have the 2010 figures in the green paper and white paper. And what a finance person or economist would do is update those to either present-day values or to 2023, as Dr. Armstrong did, and they would come up with their own model which shows that this scheme is unaffordable, and will make submissions to Parliament on that basis. So both for the people who accept the WHO approach, they would have sufficient information, and those who don't accept it have sufficient information as stakeholders to update what they have to current figures so that they can comment. You can imagine if this court refers the matter back, Dr. Armstrong will do the same exercise and bring the figures up to date if the consultation is taking place in the coming week.
Now, I'm going to be going through the record with you, and I appreciate the fact that case line is a bit faster now, but I'm not as adept at it as some of you are. So what I suggest is perhaps when I give you these references, and it's all about information, I'm going to deal with it, funding and cost and basket of services consequentially. Perhaps your juniors can have a look at it and pass you notes, or we'll make a plan later subject to the Chief Justice's directions. The first point is this one of the funding model. How is this going to be funded? And I want to suggest to you that, and mind you, what I'm going to say to you now all comes from that table, which as I have it, let me just see, just get there, as I have it, just get my note here. It's around, it's BHF 27. BHF 27, more or less ranging from pages 1429 to 1442. I'm giving you a wide span, but I'll focus my specific questions now. I'm just giving you an idea so that juniors can start having a look.
Yes.
The first pertinent issue was, how is all of this going to be funded? And as I have it, the following entities raised concerns. This is not an all-inclusive list. The Alliance of South African Independent Practitioners Association, Federated Employers Mutual Assurance Company raised that concern. Discovery Health raised that concern. Met Scheme raised that concern. Genetics Alliance South Africa, and SACTU, South African Clothing and Textile Workers Union. So they asked, this NHI fund, how will it be financed? And they asked for detailed funding mechanism and sources. And that you will find at pages 1429, 1431, and 1440. Those were the hearings on June 2021, 14 July 2021, and January to February 2022. Now this is what I have, and please dissuade me from this notion if it's wrong.
Yes.
I have it that the response was that the responses were largely absent or it was deflected. The committee referred in general references to the bill, and I want to refer you in particular to one part in that table where one of the ANC members of the portfolio committee spoke about in the response to what was raised. And you'll find that at page 1431, this response. Mr. Munyai, who is an ANC member, said, the bill only outlines principles about where the funds would be sourced and emphasized that the core funding would be the public tax, the public purse. Now, were these matters supposed to be referred to Treasury? In other words, because it was said this will be decided later on. So Treasury must obviously be on board down the line. Can you show me where, and if you can't do so now, I'll bear and have my colleagues ask questions and maybe come back to it. But can you show me where Treasury got involved? And related to that, there was mooted a possible money bill, or if not a money bill, processes to lead to a money bill to come from Treasury to deal with all of this. I think it was in the earlier, either the white paper, it may even have been in the bill. So the second related question to that, and I'm going to pause you to answer, is was there ever such a money bill, or is there evidence that there were steps taken by Treasury to get such a money bill together with a view to this?
Yes. So just to retrace, the first place to start is the bill and the accompanying memorandum originates from Cabinet, is approved by Cabinet. So when it is said at paragraph 8.9 of paragraph 8 in the memorandum that I refer the court to, that the details of new taxation options, the types are just highlighted, and the details of those will be a matter for later stage for budgeting. That is with the understanding of the Minister of Finance in Cabinet. And then you have the green paper and the white paper also saying the same thing about the sources of taxation, but saying the actual implementation of taxation options and the increases in taxes will be a matter for determination in the budget process. That's with the involvement of the Minister of Finance. I don't have the specific references now, but when the Minister of Finance was asked a couple of times in Parliament, maybe in the Portfolio Committee, he referenced about funding and sources of funding. He referenced back to the white paper that these are matters which will be addressed in the budget process. In other words, the department will bid if there's additional funding required for each of the steps for the implementation of NHI that's required to be raised, will bid for that monies through the budget process, and that will be determined there. And it's a response of the minister, and I can be helped with the references. In fact, in one of the meeting reports, maybe the same meeting of the 30th of November that I've already referred the court to, AA16, you will find a response by Dr. Crisp, where I'll ask for the actual, it's about 5 pages on. I'll just get the actual page number, where he says, on the financial feasibility model, Dr. Crisp had all the questions, quotes of the Minister of Finance, that's those quotes about how it's going to be dealt with in the budget. The department must sit almost daily with Treasury to discuss fund issues. They have constant meetings with Treasury about the current budget and the NHI and how they must go about making different changes. The fact is that South Africa has an extremely inequitable funding of health services. South Africa spends 8.5% of GDP according to the figures given to the department last week by National Treasury. That is made up of 49% spent in the public sector and 51% in the private sector. They would be happy to share the exact breakdown of figures given by Treasury. And then it talks about 15% of spending is allocated to healthcare in the public sector, the breakdown, and what I referred to earlier. But the point I want to draw to the court's attention here is the department and Treasury are in constant engagement about the funding mechanisms for NHI. And what you see at paragraph 8 of the memo accompanying the bill is that for most of the steps that need to be taken that are articulated at 8.1 to 8.2, money can be accommodated by shifting existing funding. So that doesn't require raising any taxes in the immediate term. Even the tax credits under Section 49 are not yet shifted from medical schemes to fund anything about NHI.
May I interrupt you just on that point? You see, the difficulty is this. I hear you. But the difficulty is this. How does any interested party, be it an individual user of medical care facilities or a large medical scheme, how do you assess what kind of redirecting of funds we're talking about? How do you assess what kind of new taxation is involved here? Because I think the one thing we can't deny is that this is going to be a very expensive system. Because what you are doing is you are basically amalgamating private and public medical health care. And you are saying that 49% that goes to private medical health care to cover only 16% of users is now going to be spread all over 100% or as close as possible to that. It's going to be frightfully expensive. So, is it enough to say to an interested party, like a group of medical schemes like BHF or an individual user or users, we are going to have to direct funds from other parts of the budget. We are going to have to increase tax. You are basically saying you may have to redirect funds from other crucial fundamental rights, like a budget on education or a budget on social welfare, and redirect them to, because education we know takes the biggest chunk of the budget, and redirect them to health. The point is how much? You don't have to give us exact rands and cents. You've got to give us an indication of more than 50% of, for example, education's budget are going to have to go there, or social welfare, so that we all understand as taxpayers, as corporates who deliver medical services, how much are we talking about, so that we can participate on an informed basis, not groping around in the dark. It's going to be redirecting of funds, it's going to be extra tax. How much extra tax? That is the concern that I have.
So can I just then, in respect of just the first proposition that all that NHI does is to collapse public and private and now repurpose the 49% for everyone else. That's not all that NHI does. NHI also changes the way in which healthcare is delivered to introduce efficiencies to deal with the escalating health costs in the private sector and the wastage that's identified in the papers these policies in the private sector. And you'll see in the revised white paper, there's a discussion about let me just get the reference for the court. Yes, the revised white paper. You'll see they start off by discussing the current situation, and you will, in that discussion at 003-623, you'll see the discussion about the current way of billing for private healthcare and how that drives up costs, and because of over-servicing and healthcare inflation, and you need to address that to bring it down. The route to getting from primary healthcare to a specialist, from a GP to a specialist, all of those things get reformed in the NHI. And that's what the WHO paper is important about, is that if you want universal health access, coverage that's going to work, you can't start off by transposing the inefficiencies of both the private and the public sector into the new thing, because all you'll be doing is building in those high costs into the new system. So part of the intervention is to address those inefficiencies. So, and that's relevant to cost, but those are unknowns, because one can't tell now what efficiencies you may be able to achieve, how much those will reduce in terms of costs. But that's the purpose of the NHI, and the court can't start from the premise that those efficiencies will never be achieved, because even the WHO, which has researched a number of countries that have introduced UHC, say that that has been achieved in other countries. There's no reason other than the noise about corruption, which is there. Those are things that are there.
I wanted to ask you about that. You talk about wastage.
Can I just deal with the funding issue first? The point I'm making is that, one, the court must take into account that you're not just collapsing the two systems. You are reforming the system to make it more efficient. That's the first thing. The second thing is that as it is at 8.5% of GDP, the WHO says we are spending at the top end of the developed countries. What they recommend is 5% of GDP. So there's something wrong in how we are delivering healthcare, that we're spending 8.5%, but 84% don't have access to quality healthcare. And that's part of what NHI is intended to address. So one can't assume simply that we just don't have the funds from scratch. And the question of taxation and the money bill, you can't have a money bill yet until you know what the shortfall is, at what stage of the implementation that you require additional funding from taxation. And that money bill will itself be subject to public participation, because that's a process that is required by Parliament. And the public representatives are the ones that hold the purse. This court has said in Shuttleworth, in many cases, that it is Parliament that has the power to tax. The Treasury makes the proposal to Parliament, and Parliament engages, and the opposition parties all the stakeholders will engage in that process as well. The point is there might be a case to say, if you can't tell us in clear terms what the likely cost is going to be, or the likely increase in cost is going to be, your adoption of the bill is irrational. That's a different challenge. But it can, with respect, be that because of that, there was insufficient information for the stakeholders to make comments. Because the likes of Discovery are very sophisticated. They have all this data. They can model, and they can say that this NHI is either going to be affordable or not affordable, and can make those submissions to Parliament, which they've done. And they are running those cases in the High Court on those modelings that they had prepared all along. So it is not a question of insufficient information defeating public participation. We submit that reasonable information was available. That's why Armstrong can produce a report based on the so-called deficient information. She uses the same
Can I
information.
move on, please? Mr. Maneche, can you just indicate to me, has Treasury directly, I'm not talking about speaking through the Minister of Health or otherwise, has Treasury made a direct input in any of this process? Can you show me where?
I'll ask for that to be pointed out. But you must recall, Justice Majid, that
I'm not talking about a money bill. I'm talking about inputs on, modeling of we may need to move so much or this proportion. I'm not talking about rands and cents.
yes. No, I take the question in as to be that. We'll look if there is a specific reference about Treasury providing a model. But it must also be seen in the context of the substance of the challenge that we're facing. The challenge wasn't that Treasury failed to produce a model or Treasury fails to give input into this process, so it is deficient. The primary challenge is Parliament failed itself to conduct a feasibility study to determine the sum that the implementation of NHI is going to cost. Parliament could have answered by saying Treasury has produced a report or the Minister of Health has given us something. They're saying you can't, their argument is you can't, as it were, pass the buck. It is, Parliament should have done its own work, they say, to conduct a feasibility study. What effectively they're saying, if this court in the future is faced with any legislation that has financial implications, and a party says the financial implications presented to Parliament was not sufficient for us to engage, the question is, did Parliament perform a feasibility study? If it didn't, there might be an unreasonable procedure. But that will make legislating hugely difficult, that Parliament must come with models. When grants were introduced in this country, even the relief of distress, there was a lot of noise that the country can't afford grants, but government has shifted expenditure around and we have grants. And everybody says that must stay because it serves a particular socio-economic purpose in our constitution. That's the same here. You can't say...
those grants will not cost anything close to what this NHI will cost. But let me ask you this about administrative capacity and governance concerns. As I have it, this was raised by the PPS insurance company, health administration, by DENOSA, the Democratic Nursing Organization, also the Active Citizens Movement. They asked, what are we going to do about the public sector's inefficiencies, institutional incapacity, and about corruption? You see, when you read this, when you look at this bill, it's got very noble motives. I don't think anybody can object to what is being proposed here, is to make healthcare more efficient and importantly more accessible to all in South Africa, so that you don't have a class apartheid as opposed to racial apartheid. But here's the thing, when you consider this bill against the inefficiencies you read about, not just in the media but in court papers, and also about the corruption where at one hospital 2 billion rand is pillaged, a state hospital of no major size, not a Baragwana, it's a Tembisa hospital. You must ask yourself, where does government, the respondents, answer these concerns? And this is what they say at BHF 27 at page 1437. This is a paraphrasing. The NHI fund will be self-administered. In other words, there will be no outside intervention. And the capacity will be built over a matter of time. I've not found anywhere in the papers where they address these concerns about institutional and operational inefficiencies in public health, and more importantly, the rampant corruption that, as I say, not only in the media we read, but also in court papers. If you can show me where that's dealt with, I would appreciate it. But how does one, it's the trust issue which Mr. Leach referenced.
Yes. Justice Majid, you're no doubt raising valid concerns, and those stakeholders raised valid concerns. And the purpose of public participation is that those concerns are heard and taken on board and considered for purposes of deciding on the legislative instrument. They are not a break from going ahead with the legislation merely because there are concerns. Can I deal with the institutional incapacity? The bill itself and the legislation, in the phased-in approach in Section 57, the first phase is institutional capacitation of the public health sector. They are building hospitals in preparation for this. Improving the data management, ensuring that, Justice Majid, when you go to a doctor in the Eastern Cape, and you again go to a doctor in Durban because you're visiting Durban, the data that's available can communicate. So the doctor in Durban can pick up your history from what you've been treated in Cape Town, in Eastern Cape, or whatever the place is. And those systems are part of the first phase, registering users and introducing that kind of software program. And that's one of the things that has been recommended by the WHO. And the staffing issue, which is also a resource issue. Currently, public hospitals are unable to attract specialists. Specialists are attracted by private hospitals. There are incentives for them to work in private hospitals, except that there are conditions of work in public hospitals that can improve and might account for some of that. But they are mainly attracted by income. So they want to work in the cities, they want to work where people have access to money, they can either pay from their pocket or they have access to medical schemes. As a result, public hospitals are understaffed of specialists. They don't have specialists. And you can't continue with that dichotomy in the country that, fine, we are spending all this money, but you cannot keep the proper, competent, qualified, skilled people in public hospitals because they're attracted to private hospitals, all of which absorb over almost 0.5% of our country's GDP. I accept that we have challenges. We have challenges about corruption. This was raised repeatedly and addressed, that there are mechanisms both and they go to control, and they go to the important point which this court has made repeatedly, that the mere fact that powers may be abused doesn't mean that's unconstitutional to permit those powers to exist. When they are abused, you deal with them. It's a question of enforcement, which we have difficulties with. It's not about the fact that institutions couldn't work. If it's institutional design, well, that is in the NHI, and if there are issues with it, these are debated in the public participation process. But as Mirafong tells us, the whole point is to hear and be informed by the views of the public when you adopt the legislative instrument. It doesn't mean you stop because the public don't like it. Because if you look at the side of representative democracy, all of these reports that you read say the overwhelming majority of the population want NHI. But that's not enough to answer the question, because it's only justifiable if it is viable and it's got measures in place to guard against all the problems that we see. So we mustn't forget that part of the problems that we see in the public sector that we rightly complain about are the consequence of the way in which our healthcare industry is structured, and that the NHI seeks to undo. And we submit with respect that the fact that we have this debate and the public and the stakeholders have this debate doesn't mean the legislative instrument can't be adopted. We can go and argue about the rationality of adopting it, which is what the direct challenges in the High Court are doing.
Now, I mean, I don't want to go through all of this, but can I ask you this, just as a general proposition? Do you accept that the cost of this new scheme, complete radical overhaul of health, and concomitantly the funding of that cost, A, and B, the basket of services, by what point does the medical scheme's role become complementary to what is offered? Because that presupposes that we meet a point where we can say, these are the services that are on offer, and you must tell the public that. These are the services that will be on offer under this bill, and medical aid schemes will only, because a single payer, single funder system, the NHI fund, medical services will only top up, complement those at a certain point. That's what the section says. So we need to know what the basket of services, not in exactitude, but we need to know what are we talking about here. So A, cost and funding, B, basket of services, and then this benefits advisory committee. We need to know this body with vast powers, unelected, and to me, and please dissuade me again if I'm wrong, with unconstrained powers as to what and what they cannot decide and what they can do. A la Dawood, where do we see the guidance as to how this vastly powerful unelected body, not accountable to Parliament, will exercise their discretionary powers? And related to that, the Minister, a lot of these things are left to the Minister for regulations, and we know what this court has said over and over again about the tail not wagging the dog. Do you accept that those three was fundamentally important for any user, medical user, be it a medical aid or a group of medical aid schemes, or an ordinary user wants to go to Baragwana or wants to go to a private hospital? What does all this mean? What input must I give into this important bill?
Let's just start with the basket of services, because that is part of the challenge. But one must understand the challenge we are facing from BHF is that the basket of services should have been detailed in the bill. So they must be included in the legislation. And the answer to that was, that would create rigidity, because you can't respond quickly to changes in circumstances, including the change in the burden of disease, in order to change your benefit basket. That's the answer that was responded to, and we must put that in regulations. And they say that they challenge that. Now, they challenge it. They can't challenge it on the basis that that's an impermissible delegation, because that's a substantive challenge. They challenge it on the basis that because you didn't include it in the bill, we don't know what you're going to provide, and therefore we don't know what's going to cost you. But with respect, under the current system, you don't have benefits detailed in legislation. The Medical Schemes Act, which this court dealt with in Genesis, and dealt with the business of a medical scheme. Under the Medical Schemes Act, there are minimum benefits which are prescribed that medical schemes must provide. And those are prescribed by regulation. So the section simply says, section 29(0), that there must be prescribed minimum benefits, and regulation prescribes them, providing for that flexibility. The same with the benefits for medical schemes. When you want to know what you're entitled to for the money you pay the medical scheme every month, you go to the rules of the medical schemes, which are subject to change every year by application to the Registrar of Medical Schemes. When medical schemes started, wherever in 1967, nobody said, let's work out in advance and list the benefits which medical schemes are going to provide so that we can determine what the cost implications will be for GDP. So that's an understandable approach. What you can do is you must explain the levels of care that you expect NHR will provide. We can talk about primary health care. What will be in the primary health care, early child care, and the likes. And then
Does the bill tell us that?
Well, in the phasing in at section 57, it tells you in the first phase, these are the services we're going to buy for the public. We're going to maternity services, this and that it does.
I would love a reference to the record.
Yes,
if your juniors can check.
I'm referring to the section, but that's, as they say, it was unchanged from the adoption to signing. And so you can know the level at which, a level of care that will be provided, but not the detail of the actual services, the basket of services. And there's nothing wrong in that. And so they want to put the cart before the horse by saying, you can't do the costing without knowing the basket of services. But at the same time, when we answer that, but basket of services by regulation, they say, well, then you can't give us the costing, so you don't give us sufficient information. The second point raised is when do medical schemes start providing complementary services? Section 33 of the Act, which was Section 33 of the bill, says that medical schemes only start being constrained to provide complementary services upon full implementation of NHI. And that we have reached that stage will be known when the Minister of Health, by regulation, declares to the all and sundry that NHI has been fully implemented, meaning that we've gradually got to that point of the development of universal health coverage that NHI can provide the full basket of services, or just minus maybe certain more specialized services that NHI will not fund. At that point, so there will be a line in the sand. But this will be a developing story. And the Minister of Health engages with the industry, so they would know how far NHI is in the rollout. But that immediately tells you, with respect, Justice Majid, that you're not going to have this exponential cost immediately, because that programmatic introduction of NHI to reach a point where it's fully implemented is, by legislation, subject to resource availability. So if resources are not available, you may end up at a point where medical schemes still provide supplementary cover and not complementary cover. So it's not unclear. But it was debated and the answers were given. But it depends on where, you can't satisfy everybody, but that's not the requirement of the law, it's just reasonable engagement. Then there is the Benefit Advisory Committee is not unconstrained with respect, because if I recall, the fund is a PFMA fund, and there are constraints in law. AAA, that judgment about what is it? I can't recall whether it's AAA automobiles. The judgment of Justice
AAA investments.
AAA investments, yes, talks about, as long as you are performing a public function under statute, you are subject to the legal constraint under the Constitution and statute, and you are subject to review, and so they are subject to control. But also, if there are deficiencies in the architecture of the legislation in the way in which it establishes the BAC, it is not a failure of public participation. It's a failure for the legislator to legislate probably rationally, which might be an issue of a direct challenge, or maybe a misconstruing its powers and the like, and delegating all these powers. But all of that is a substantive challenge. It's not a public participation challenge, because these issues were raised and were debated. So it is an overhaul. Justice Majid, you are right. It is an overhaul, because it's not a collapsing only. It is really rejigging the system. And we are not alone in doing this. And the WHO is driving this because of the suffering that it causes in countries where you have this kind of inequality. And we have the highest, what is it called, Gini coefficient. we're the worst in the world. So it's not a matter of public participation. There might be an issue about rationality, but that's for a different debate.
Which brings me to my last question. I'm taking too much time. So, as I said to counsel for BHF, Mr. Leach, my big concern in this case, as far as the applicant's case is concerned, just switch off your mic, please, Mr. Manager.
Oh, yes, sorry.
The transcribers say that they can't pick up. Thank you. So my biggest concern was this jurisdiction issue. And he relies on the Lamosa judgment, basically paragraph 7, which is a conclusion of what precedes, it's a discussion of paragraphs 2 to 6. And he says that in Lamosa there was, as you know, a primary challenge on public participation, but there are also substantive challenges, which was ancillary, but not ancillary, which was brought separately. But you say it doesn't avail the applicants because Lamosa has two clearly demarcated causes of action, if I might call it that. They have a primary constitutional challenge, in which they rely on exclusive jurisdiction. But you say that there they had a direct access challenge for the substantive issue. So are you saying that therefore Lamosa doesn't assist them because they didn't bring a direct access application in respect of the rationality challenge? He did say it's preceded by 2 to 6. He did say that. Unless my note is wrong.
Yeah, he's truly my friend, so I wouldn't suggest that he was taking a fast one on the court. But it is important to emphasize 2, because 2 does say they brought an exclusive jurisdiction challenge and sought direct access for the substantive challenge. And the court is correct, and the words, and I'm not purporting to quote you verbatim, Justice Majid, saying, are you saying Lamosa brought separately the secondary challenge? Here you don't have a separate challenge brought as a substantive challenge. It's all in an omnibus challenge. And we had to answer all of it. To say there is no unconstitutionality here. They say, then it's clear from reading all of this that they are complaining about the outcome. And I'm borrowing from Justice Rogers' question, I accept it's not a conclusion, is a question put, that if you're complaining that sufficient information wasn't given, which was available but Parliament withheld, as in Corruption Watch, that's a different case. But if you're saying Parliament withheld because it took a different view about whether the information is necessary or not for a proper public participation process, surely when they adopt the bill, your criticism is that the outcome is irrational. That's exactly the language used in these papers. Not just throwaway paragraphs, but where they say drawing everything together that we've complained about and what we are about to say below, this is the conclusion we arrive at. And I've given the court 212 to 214 of the founding affidavit. So we submit that, but ultimately it's the court's assessment, but this is the case where the court should engage with the substance of the challenge, the core of it. And our submission is the substance of this challenge is an unhappiness with the outcome.
That's the last question, but I got to ask this. In the event that we are with BHF on the procedural challenge, on the public participation challenge, what do you say should be the remedy? Do we start de novo afresh, or what should we do?
Yes. We discussed it. It's not an easy, it's an easy question, but a difficult answer to give.
Usually, that's why I'm better off sitting this side.
Because, and I'm not suggesting, I know Justice Majid thought about the answer, and it's a difficult answer. So if we had completed the debate by the end of tomorrow, and the court said, what if we don't agree with you on the NCOP? My answer would relatively be easier because we've already made that submission in our heads. But in the continuous NA process, it's very difficult to find a place, a line where you can say the complaint starts here and it may have gone wrong from here onwards. And we would err on this. We are a parliament. We should be asking for less work because we've done that much work to get here. But it's probably the kind of situation where if you disagree with us on the NA process, it should just be remitted. It goes back to Parliament, and Parliament must assess where it should start. And we embrace the arguments both of the Western Cape and our learned friends for BHF, my learned friend Mr. Leach, that it's open to Parliament to say we had done good work until here when BHF started complaining, and maybe we start there.
I think what he suggested makes sense, and that answer you just gave is good enough for me. It's difficult to say. But I would suggest that the themes that were raised as challenges, that you don't need to redo that. I mean,
Yes.
I'm not saying what Parliament should do, but it just seems to me from where I'm sitting, not being a parliamentarian, that is a point where you can say, let's address these and see what we think we've addressed adequately. It's your prerogative, it's your call, and then deal with the others where the court in the judgment says, I'm just speaking hypothetically, where we have not done enough.
Yes. If you, for instance, say to us, Parliament should have conducted a feasibility study on the cost and funding, on the cost, and then produce a funding model. That's the obligation that the court says the Constitution places on Parliament when it legislates. Then it'll start there, probably, but that's a matter for Parliament. But we submit that the court won't get to that point because it'll just make lawmaking wholly impossible. It's not a reasonableness test. That's a much higher standard.
Thank you, Chief Justice.
Thank you.
Thank you, Mr. Maneche. Just two questions from my side. I think I agree with my colleague that there's a lot of anecdotal and other evidence about maladministration and corruption in the public health sector. But equally, there are also shining examples of the public sector working well. I don't wish to give evidence, but I visited a major public hospital in Tshwane yesterday, where well, let me not give evidence. But just to say that, and I don't think my colleague suggested that everything is bad. But let's assume that there was an unanswerable case on maladministration and a lack of capacity that was made out, that neither the minister nor Parliament could answer. What would you say that would trigger? Would it trigger a challenge to the validity of the bill based on a lack of public participation? Because there's nothing more for the public to say. The public has participated, they've said the system is not working. And that raises the question of the means and the end, whether you have the means to achieve the end. And similarly with regard to the budget, whether you have the finances to achieve the end. So it would seem to me that many of these complaints, if they were valid, and I say it's subject to that, would classically fall within a rationality, legality challenge.
Yes, we would fully agree with that. And the court dealing with a legality challenge or a challenge based on the Bill of Rights that is regressive, the measure is regressive, will be able to say, these are the areas we are convinced there is a shortfall, and Parliament will consider that and improve the legislation. It's not throw in the baby with the bathwater. The same with the budget. If we can't afford it, and that's the rationality challenge, it may be that Parliament reconsiders how this is rolled out or how it's designed. It might go to the design of the NHI. And just to echo the first point, and I accepted Justice Majid was asking in that context, is that there's also anecdotes of private sector corruption in the private hospitals, medical schemes, all of that. It's a malady in our society.
Yes, but here we're dealing with an NHI bill that focuses on the public sector in the main.
Quite.
Yeah, okay.
But it seeks to address the problems in the private sector also. Thank you, Justice Kolape.
Mr. Maneche, just one point. I just need more clarification on the distinction between this case and Corruption Watch. As I understand things, central to the bill or the act as it is now is the establishment of a centralized fund to achieve all these objectives that you've stated. Isn't costing and funding central to the public participation process, similarly to how the CVs were found by this court to be central to recruitment of commissioners in Corruption Watch? What's the distinction?
Yes. Can I just, if the court will bear with me. So if you look at Corruption Watch, the the real point there is you are unable to meaningfully comment on the suitability of the candidates unless you know their experience, their qualifications, which you can only see in the CVs. And the CVs were not provided. It wasn't the CVs were provided in an insufficient form. The CVs were not provided, they're available, they're not provided. There was no debate about the form in which the information must be presented to enable proper public participation. So you were unable to comment meaningfully on the suitability of the candidates without the CVs. Maybe qualified reasonably, unable reasonably to, because the standard is reasonableness, I would accept that. But when you come to our case, firstly, we accept that costing and funding are important to this bill. It is correct. It is. Because it is going to affect cost, it is going to affect funding. The difference between BHF, Parliament, and the Minister is they say the form in which the information should have been provided is this. You must give us a feasibility study or a model which can tell us what the full cost of this project is going to be, and tell us now where you're going to increase and which taxes to fund any shortfalls that emerge. And on the other side, we say, now we've provided you the information, firstly in relation to the financial implications. All we need to show you and all we can do is to cost the steps towards, as we implement towards universal health coverage, because we don't have the shortfalls you're talking about in year 1 and year 2 and year 3. Maybe in year 10 we have the shortfall when we're close to fully implemented and the minister can gazette that medical schemes must now provide complementary services. So that's the first point. So we've given something, they say the package is not sufficient.
Can
I just conclude? Can I just add the second one? Dambuza, maybe let me hear the question first and then I can add.
So what you referred to is what is in page 32 of your heads, the financial implications on the state, which is your paragraph 8.
Yes, that's the paragraph we've quoted.
So that's the sum total of what you say. We've given you, it is sufficient for public participation process, for meaningful participation.
So it's the first aspect. Okay. That's the first one. We've given you that. If the court accepts that it was justified was reasonable for Parliament to accept the WHO advice, as we interpret it, that all we can do reasonably is to cost the steps of implementation and not the final figure, because that is unhelpful to do. If you accept that, then you'll accept that what Parliament did was reasonable. But you don't have a basis to reject it, because that same advice is accepted even by the advisor to BHF, other than that she interprets it differently. But I just want to say that that's the one class of information that we say we provided in line with the WHO report. But there's also another line which they say is deficient, and that is the outdated figures of 2010. That is in the green paper and in the white paper, that say we're using current unit costs and utilization in the public hospitals. We take that, we multiply by the number of users, and we get a number. I may be wrong about the formula, but that's something like that. Now, what the WHO says about that is, when you use current unit costs, you are incorporating in all the inefficiencies that exist now. But also you're using unit costs in the public sector. You're forgetting about unit costs in the private sector, which are higher. So which unit do you use? Experts can debate until the cows come home about which one is better. But the point is, in the green paper, the department used unit costs and utilization in public hospitals to come up with an estimate. They said these figures are only illustrative because they are based on assumptions, and assumptions can change. What Dr. Armstrong did was to take those figures, illustrative as they were, based on assumptions as they were, and updated them to 2022-2023. And on her assessment of that, worked out that the total cost produces shortfalls that the tax base in South Africa can never afford. And based on that, she says, they should not have adopted this bill. Now, any stakeholder, and Discovery tops them all on this, and you can read the judgment of this court in Mediclinic, you will see the quality of data that Mediclinic had, that it used to contribute to the debate about the merger in that case. That they can quite easily update those figures with the data they have to enable themselves to make submissions to Parliament that you can't adopt this, is not affordable. Is not, so what we are saying, firstly, is the bill was sufficient. That's the first point I made. The second point is, for these stakeholders, all you need to give them is the starting figures. They are able to update them and make assumptions about the growth in the economy and growth in GDP and the rest, and work out a number. And they can make submissions. They have made those submissions. They have said, this bill is unaffordable. They've said it.
Okay, that talks more to the costing, I suppose.
Yes.
Where do I go for information
For
on
the
the funding?
So the funding, the memorandum tells you in exact figures the funding for the first three or four steps of implementing NHI. So they can tell you we are going to have to engage in improvement in public health facilities. They can say it will cost us this much. We are going to introduce this program for proper management of data. It will cost us this much. Until we've done that, and we must establish the fund, it's going to cost us this much. Until we've done that, we can't even start purchasing services, benefits for the public. We can tell you all of those costs, but what we can't tell you is, we can also tell you that we are going to shift so much from grants, which are given in that table. We're going to redirect those to the fund. We're going to redirect provincial expenditure to the fund, because they will now be, in a sense, agents. They can tell you about existing funding which they can be redirected, tax credits, and how much those are. That's funding, that's part of the funding. What you can't tell today is what the department will ask in the form of a money bill to fund a particular stage in the NHI, which may be reached in 5 years' time. That's a matter which both the memorandum and the green paper and white paper say it's a budgeting issue. It will be debated in the budget process. And that process is engaged in by department proposing to Treasury, Treasury going to Parliament with a money bill, Parliament debating these things and approving or disapproving, as it did with VAT. That's Parliament that taxes. So that will take place in that same House, which has approved the bill, as to whether this funding can be made available. So we submit with respect, it's not an issue of insufficient information disabling proper public participation. We told you this is unaffordable and you went ahead.
So just for my benefit, what is the summary of the submissions on where the funds are going to come from?
The summary is, so in the memorandum, you will see...
I saw the memorandum. It doesn't really help me much, because it does not set out very clearly how much or how much will be moved from where to meet costs at which stage, at which of the stages beyond paragraph 8.
Yes.
I just couldn't understand it, and I was wondering, if I don't understand it to the extent I don't, how much more an ordinary person that, is even less skilled than me.
That's correct. But you must also ask how much more will BHF understand? because you're dealing with the public that includes the ordinary person and the stakeholders. I accept the,
Well,
the
I've
challenge.
got to make a decision as
Yes,
well
I accept.
now, so
Yes,
I need to understand.
No, I was just adding to the point that if Justice can't understand with respect, how would an ordinary person understand it?
Yeah.
I'm just saying that Parliament is not only dealing with the ordinary person, it's also dealing with the stakeholder who is sophisticated. But to come to the question, Justice Dambuza, the redirecting of funds is clear because the bill tells you grants, we get so much we can redirect. There might be redirecting of other expenditure that's not visible to the court. That is a matter for budgeting. So I can accept that so we can't tell you now that they will shift so much money from a particular vote.
Yeah. So you haven't said anything about it in your heads because I couldn't get anything.
Other than
A
what?
summary that.
No, the reference that Justice Zambuza referred me to, that's the reference that discusses the funding point. But what I'm saying is, they are also in those we discussed the taxing point. What we are submitting with respect is that you can't expect either Parliament or the Minister to tell you with any specificity that we will require so much from payroll taxes or so much from surcharges and at this specific point. Because it may be that at that point in time, what is available is sufficient, so you don't raise taxes. But that's why courts are, with respect, can't descend into asking questions about budgeting and planning and policy and say, but tell me precisely where, when you're dealing with public participation, all that you are asking at the level of public participation is, was there a reasonable opportunity given to the public to make a meaningful input? If the court decides that the only time that the public could make a meaningful input is if there were exact figures given about what will be raised by way of taxes to fund NHI throughout the 10 years or 20 years of implementation. And absent that, this public participation process is unreasonable. Well, with respect, submit that is setting the bar much higher than any of the cases before today have done. Because it's not asking for perfect information. It's not asking for complete symmetry of information as between the policymaker and the public, that they must be see-through. The public must know what you're doing about where you're shifting what to what. There is a level of discretion that is given in the reasonableness standard for the fact that the decision maker can err within a range. And we submit it didn't err by adopting what the WHO advised and putting up the financial implications in the way in which we did in the bill. That's the first answer. The second answer is Dr. Armstrong demonstrates that the minimum information that was available in the Green Paper was sufficient for her to model what she could say to BHF, show the government it's going to be unaffordable. That is public participation.
No further questions for you.
As the court pleases. And I do thank the court for the engagement.
Ms. Pillay.
Thank you, Chief Justice, members of the court. We intend to address the following issues, Chief Justice, in the following sequence. Firstly, we will touch on the broader context within which this court has to consider the public participation challenge brought by BHF today. Secondly, we'll deal with the question of public participation and how this relates to BHF's primary complaint that there was inadequate information in respect of cost and funding and in respect of the basket of services. Thirdly, we will deal with the complaint that Parliament had a closed mind and that the process was predetermined. We'll touch briefly on the complaint of a vague operating model, and if time permits, touch on the question of remedy and costs. If I can then begin with the first topic, which is the broader context. This court will know that the jurisprudence of this court is that an inquiry into whether or not public participation was reasonable is a contextual inquiry in which this court must take into account a range of factors and consider those factors cumulatively. We would submit that one of the clear factors the court must consider is the purpose of the NHI Act, now then bill. And part of that inquiry would be understanding the problem that the NHI seeks to address. And the issues which I will traverse now, Chief Justice, are extracted from the Green and White Paper, and I will do that very briefly and thematically. And they are the following. The first one is rampant structural inequality. The NHI recognizes that South Africa operates on a two-tier health system rooted in its unequal social and historical past. The existing two-tier system is developed within a deeply unequal social and historical context, has resulted in a concentration of resources, skills, and services, serving a minority of the population, while the majority rely exclusively on an under-resourced public system, fraught with numerous challenges. The latest figures show more or less a 51% allocation of funding of total spend on private healthcare, despite the fact that the majority of our country are serviced through the public healthcare system. The result is that a minority of the population benefits from a well-resourced private sector, while the majority depend on an under-resourced public system. Even within the context of the private medical system, where the privileged few can afford to have medical aids, there are problems which the NHI system recognizes. One of this is the increasing costs of medical schemes. The most reliable source of healthcare financing for individuals is medical schemes and hospital cash plans. However, to ensure their sustainability, many schemes resort to increasing premiums, making them more and more unaffordable to ordinary South Africans. They also resort to decreasing member benefits, leading to members exhausting their benefits by mid-year, and then potentially becoming a burden of the public healthcare system. Another problem is out-of-pocket payments and co-payments, which are built into the medical scheme's benefit structures, and which have to be made by people on medical aid, which render ultimately medical care unaffordable. And underlying all of this is a problem highlighted by the WHO, which is of the uncontrolled commercialism of healthcare. This, despite the fact that we must recognize that healthcare is a necessary social good. Against this backdrop, incremental reforms have repeatedly failed to overcome entrenched inequities in access, quality, and health outcomes. And the implications of all of this for the constitutional rights that we seek to uphold is clear. The right to adequate health care, the right to equality, the right to dignity. And then this leads to the stated purpose and objectives of NHI. The NHI Act is transformative. It doesn't seek to reform the healthcare system. It seeks to overhaul the healthcare system. It is a healthcare financing system designed to pool funds to purchase quality, affordable, personal healthcare services for all South Africans based on health, need, and not wealth. The Act recognizes that access to healthcare is foundational to the realization of all other rights, in that it determines whether people live or die, whether illness and disability are prevented or treated, and whether individuals are able to work, to learn, to care for their families, and to participate meaningfully in social and economic life. And so we must understand that the NHI represents a substantial policy shift that will necessitate a massive reorganization of the current healthcare system. And it's necessary to address structural changes that exist in both the public and private sectors. And so when you see that the NHI establishes an NHI fund as a single purchaser and a single payer of covered healthcare services, the reason behind that becomes clear. The fund will negotiate contracts. It will pay accredited public and private providers on behalf of the entire population. What it will do is to pool funds between the public and the private to eliminate disparate parallel financing streams and duplicated capacity. Ultimately, the NHI seeks to establish universal entitlement. Eligibility for covered services is based on health need, and not ability to pay or insurance status. And that, we submit, is a necessary contextual factor which this court must take into account when it considers the question of public participation. And bear in mind that before the NHI bill was tabled in Parliament, the NHI bill was placed before Cabinet. The bill, the memoranda, the accompanying documents were placed before Cabinet. And Cabinet approved the NHI bill. And in fact, if you read the green paper and the white paper, Cabinet not only approved the bill, it asked for specific clauses to be included, which set out potential sources of funding of the NHI. Those are section 48 and 49. They find their way into the NHI bill at the behest of Cabinet, who speaks on behalf of all the members of the executive, including the Minister of Finance. And so we submit, when the court approaches the matter, do it on the basis that Cabinet has made a clear policy choice about what it wants for South Africans, or for people, the population of South Africa. And when the bill is placed before Parliament, it is placed before Parliament as a result of that policy choice made against the backdrop I've just described. Against those factors, we deal with the question of public participation, which is the second topic I intended to address. Now, we accept that public participation is a crucial part of a participatory democracy. It affords the public a meaningful opportunity to participate in legislative processes. It gives members of the public a meaningful opportunity to know about the legislation under consideration, to understand the issues on which Parliament seeks input, and to make representations capable of influencing the legislative process. It's interesting that on the admitted facts in this matter, there were, in the words of BHF, and not in the words of any of the respondents, there was an intensive and extensive public participation process, which ranged over 4.5 years. This wasn't a rushed process. It wasn't an emergency process. It was a 4.5-year process, starting before COVID, straddling through COVID, and culminating in 2023. Now, my learned friend, Mr. Maneche, has touched on some of the features of the public participation process. And Chief Justice, I gave an undertaking not to repeat, but some of these numbers I think are important because they give context to the debate, and I'm going to cover some of the numbers. The public participation process started on the 7th of August 2019, and in the National Assembly it concluded on the 13th of June 2023, just short of 4 years later. Multiple rounds of written submissions in both the National Assembly and the NCOP were held. Between 26 October 2019 and 24 February 2020, the National Assembly's Portfolio Committee held some 33 hearings. These hearings were attended by 11,564 members of the public and stakeholders across 33 municipal districts were heard. 961 oral submissions were heard. In addition, the Portfolio Committee held 29 virtual meetings at which 114 stakeholders made oral submissions, and that was over the period May 2021 to February 2022. The Portfolio Committee received approximately 338,891 written submissions from the public. All written public submissions were captured into the metadata by Parliament. They were categorized, they were analyzed, and they were processed by Parliament. None of this is disputed. The Portfolio Committee held 11 meetings at which a clause-by-clause analysis of the NHI bill took place. I want to repeat that because that wasn't covered by my learned friend, Mr. Manechi. 11 meetings were held by the Portfolio Committee in which they did a clause-by-clause analysis. The department on various occasions was called upon by the Portfolio Committee to respond to issues raised during public hearings and during submissions. And what the chronology which is on case lines tells you is that the Portfolio Committee met subsequent to hearing from the department in order to consider the input from the department and how it related to the submissions received. The Portfolio Committee received legal advice on issues raised during the public hearings, and they also deliberated on the advice received. There were two legal opinions, one from Parliament's legal advisor and the other from the State Law Advisor, which both served before the Portfolio Committee, debated and discussed. In addition, the DA and Freedom Front Plus sought an opportunity from the chairperson of the Portfolio Committee to obtain their own opinions, which they did. Those opinions were then placed before the Portfolio Committee, debated and discussed. The Portfolio Committee considered consolidated public submissions and proposed amendments. Those amendments, then they agreed on a list of proposed amendments which became known as the A-list. This A-list was eventually what informed the bill which was adopted by Parliament. And throughout all of this, there's a startling feature that's dealt with on the papers and in the answering affidavit of Parliament. And that is that the majority of submissions and comments received through this extensive and intensive public participation process was in support of NHI. Similarly, in the NCOP held 60 public hearings in its 8-week process. Multiple meetings were held where the department was called upon to respond to issues raised during public hearings and submissions. The Select Committee provided a report and explained in that report that all submissions received were captured and were sent to the department and parliamentary legal advisor and state law advisor to consider. And ultimately, the Select Committee debated negotiating mandates from its 9 provinces. Now, the BHF doesn't dispute any of these facts. You've heard my learned friend for BHF argue today that what we're looking for is a qualitative approach and not a quantitative one. But we submit with respect that that's not correct. The quantitative element that you see reflected in the process followed is profound. Because what that means is that this public participation process played out on a wide scale, drawing on as many ordinary people who wanted to have their voices heard on the NHI. And so there must be a quantitative element to it. We accept that there must be a qualitative element. And that qualitative element the court will see playing out in the reports attached to the various affidavits. The one in particular being the 30th of November 2022. And my learned friend, Mr. Maineche, has already dealt with that report at length. If one goes through that report, Justice Matopo, in response to a concern that you raised, if one goes through that report, it takes you chapter and verse into the debate between members of the committee on financing of the NHI. And so when my learned friend says to you that there's no evidence of engagement, we submit that the evidence is there. What my learned friend is unhappy with is, despite that engagement, the outcome is not the outcome that the BHF wanted. Against that backdrop, I turn to the first leg of the challenge, which is the request for information argument. And perhaps before I do, let me headline the argument which I will develop before you today. And it's the following. This question of basket of services and the question of financing, legislative choices were made in relation to both. And those legislative choices were in the very bill that was tabled before Parliament and which the public had an opportunity to engage with. And I'll take the court through those legislative choices to see how they were developed in the bill. If I can ask the court to turn up the bill, it's BHF 14. And in particular, section 57 of the bill, which you'll find at 003-814. Now, the heading there at the bottom of the page is transitional arrangements. You'll see section 57(1)(a). Despite anything to the contrary in this act, this act must be implemented over 2 phases. And then importantly, and this is probably the most crucial section of the entire bill, and you'll see it in the act as well, national health insurance must be gradually phased in using a progressive and programmatic approach based on financial resource availability. And it's in the Act. And that's the handbrake, that's the brake that's built into the Act. Whatever happens in the Act, how the Act is implemented is subject to financial resource availability. The Act says then in 57(2), the 2 phases contemplated in subsection 1A are as follows. And you'll see that the Act contemplates 2 different phases, the first phase being a 5-year phase, and the second one being a 4-year phase. In relation to the first phase, which is phase 1, the dates don't matter because obviously time has passed, but it anticipates a 5-year period during which the following must happen. In 1, continue with the implementation of health system strengthening initiatives, including alignment of human resources with what may be required by users of the fund. 2, include the development of the NHI legislation and amendments to other legislation to give effect to the NHI Act. 3, include the undertaking of initiatives which are aimed at establishing institutions that must be the foundation for a fully functional fund. And 4, include the purchasing of personal healthcare services for vulnerable groups such as children, women, people with disabilities, and the elderly. If I can just stop there, Justice Majid, this is the reference you want. There is a defined basket of services built into the 2 phases of the Act. And if you read that with subsection 4, which are the objectives that must be achieved in phase 1, they include the migration of central hospitals that are funded, governed, and managed nationally as semi-autonomous entities, the structuring of the contracting unit for primary health care at district level in a cooperative management arrangement with the district hospital linked to a number of primary healthcare facilities, the establishment of the fund, including the establishment of governance structures, the development of a health patient registration system, my learned friend Mr. Maineche has already referred to that, contemplated in section 5, the process for the accreditation of healthcare service providers, which must require the health establishments are inspected and certified by the Office of Health Standards Compliance. Health professionals are licensed by their respective statutory bodies, and healthcare service providers comply with criteria for accreditation. And you can see quite an in-depth almost preparatory phase for full-blown NHI. The last one, Justice Majid, in answer to your question, it must include the purchasing of healthcare service benefits, which include personal healthcare services defined in the Act, such as primary healthcare services, maternity and child healthcare services, including school healthcare services for the aged, people with disabilities, and rural communities from contracted public and private providers, including, and then the list goes on of the healthcare service providers who have to be contracted. And so what you see here, in the at least the first phase, and we'll deal with the second phase shortly, but it's a clear plan of implementation. All of this subject to the requirement that implementation must be programmatic, and it must be structured, and it must be subject to available resources. And so when this bill is released for public comment, the bill builds into it a particular design by choice. And that is what the public was asked to make submissions on. And so when there was a demand from bodies like BHF that say to you, cost NHI now, otherwise we can't consider the Act. The response was, if you look at the bill, it has a particular legislative design. Implementation will be on a programmatic basis. It will be gradual, and it always is subject to the availability of resources. So we can't cost the entire thing up front. It may take 5 years, it may take 10 years, it may take 15 years to reach full implementation. For that reason, it was completely unhelpful to cost the NHI up front. When that conversation was happening with BHF, it was about legislative design. It wasn't about information needed in order to engage with the possibility of the NHI bill being passed. And similarly with the basket of services. If the court has regard to the bill and the definition of the basket of services, and perhaps I can ask the court to look at section 25 of the bill, which is the Benefits Advisory Committee. And if you look at 25.5, the Benefits Advisory Committee must determine and review. And so firstly, before I get there, I think Justice Majid, you raised the concern that the Benefits Advisory Committee is not a representative committee, it's not a parliamentary committee, etc. If you look at subsection 2 of 25, it deals with the membership of the Benefits Advisory Committee. These are persons appointed by the minister, but it must consist of persons with technical experience in medicine, public health, health economics, epidemiology, and the rights of patients, and the one member must represent the minister. And subsection 5 says that the Benefits Advisory Committee must determine and review the healthcare service benefits and types of services to be reimbursed. This is important at each level of care, at primary healthcare facilities and at district healthcare facilities, regional and tertiary hospitals. It's quite a complex task allocated to the Benefits Advisory Committee. Secondly, they must determine and review detailed and cost-effective treatment guidelines that take into account the emergence of new technologies. Now, we understand new technologies do not only mean medical technology, but also advances in treatment. And what the Benefits Advisory Committee has to do is to keep abreast of those developments, to ensure that its decision-making is informed by the latest in that space. And thirdly, the Benefits Advisory Committee must determine and review, in consultation with the Minister and the Board, the healthcare service benefits provided by the fund. That's the basket of services. The Benefits Advisory Committee doesn't determine it on its own. It does so in consultation with the Minister and the Board. And so the need for flexibility of the Benefits Advisory Committee is clear. This is a committee that's taking decisions based on the latest evidence available to it in relation to treatment and technology. You cannot calcify that, the basket of services in legislation. So to go back to costing and funding, I've demonstrated to the court that the bill had built into it a legislative choice, a design that was put up by the department for consideration, and which explains then the department's approach, which it repeated again and again and again, that it was impossible to cost the full implementation of the NHI project then and there. That implementation would be programmatic and gradual, and at each step of implementation, a costing exercise would be done for that particular step, which is exactly in line with what the WHO advised. Against that backdrop, the question was raised, what information was made available? I think it was done by Justice Dambuza. What information was made available to the public to allow them to engage with this? The first answer, Justice Dambuza, it was the bill itself, which contained the legislative choice. Secondly, the green paper contained what it called an illustrative costing exercise, where it made certain assumptions, and based on those assumptions, it assumed a package of benefits, and it assumed a period. And using those two factors, it had made an illustrative costing exercise, also in line with what the WHO advised. The WHO said for policy purposes, you must throw out something. That costing exercise had to build into it assumptions because there is no defined benefits package and there is no defined time period for implementation. And I've taken the court through that. And for that reason, those assumptions were built into the green paper. But for all intents and purposes, that modeling exercise was done and was made available to the public. And it's the very reason why BHF was able to, in a sense, update the numbers in that modeling exercise in order to bring it, I think, all the way up to 26, 27. The second thing that the public had at their disposal was a chapter in the white paper, which the court will find at 004-442. The heading of that chapter is Financing of NHI. It's an entire chapter in the white paper dedicated to the different methods of potential funding of NHI. The third thing is that there was a memorandum which accompanied the bill. My learned friend, Mr. Maneche, has dealt extensively with that memorandum, in particular, paragraph 8 of that memorandum, which dealt with financial implications. And fourthly, the bill itself identifies possible sources of funding. If the court looks at section 48 of the bill, and that's at 003-811, the chapter is financial matters. Section 48 says the sources of funding, the revenue sources for the fund consists of, and then it lists a number of revenue sources. It then deals with chief source of income, and the fund is entitled to money appropriated annually by Parliament in order to achieve the purpose of the fund. Now, what that does is it subjects these requests that will be made periodically by the fund in order to secure its implementation going forward to the ordinary principles governing public finance. And so no money is going to be appropriated to the NHI, which short-circuits that process. And the very purpose of that process is to protect principles of accountability, of transparency, etc. So the combined effect of the two features of the bill, which I've just taken the court through, which is the programmatic approach. I've learned a lesson from my learned brother, Chief Justice. It's one more topic to deal with, which hasn't been dealt with by Mr. Maneche. I promise you it won't be long. Very briefly, the complaint that Parliament closed its mind. I only want to highlight to the court one thing, and that's this court's judgment in Merafong, where a very similar complaint was raised, that the ANC had decided on a particular policy and Parliament just was implementing that, and it closed its mind and delivered on the promises of the ANC. And the court held in that matter that you cannot just make such a heavy-handed complaint without one iota of facts to support it. There has to be some sort of factual foundation to support what really is an egregious complaint. You're saying that members of Parliament failed to carry out their duties as honorable members. And so similarly, like in Merafong, in this particular case, there is not one fact put up in support of the allegation that the members of Parliament closed their minds and just went through a 4.5-year process for the sake of it. And I want to read to you, the last thing I'm going to do, Chief Justice, is read to you paragraph 66 of the founding affidavit, which really is the high watermark of BHF's complaint. And they say the following: the impression that these representatives of BHF gained, and in the previous paragraph they identify certain individuals that attended some of the hearings. This is what they say: the impression that these representatives of the BHF gained, and that was conveyed to me, was that the hearings were really no more than Parliament going through the motions. And that's it. That's the basis on which they come to this court and say that Parliament closed its mind. It was an impression created. This despite the very extensive and intensive process which they recognized over 4.5 years. And for 4.5 years, they would have us believe on no evidence that those members of Parliament were just going through the motions. Those are submissions, Chief Justice.
And the question Mr. Maneche found difficult to answer, if we still find a procedural defect in the public participation process, what just and equitable relief should we grant?
Chief Justice, the answer, unfortunately, like you said, is a difficult one because it would depend on the nature of the defect identified by this court. It was difficult because the complaint is that members of the public didn't have sufficient information being provided to them. If that's the complaint, and if that is upheld in the unlikely event it is upheld by this court, it changes everything from day one. Because how are you making submissions if you don't have the full body of information at your disposal? And so the answer, it's an unfortunate one because it sounds like I'm dodging the question, but it really would depend on the nature of the defect identified. It's an easier question to answer in the next case in Western Cape, because there it's quite clear if there's a defect in the NCOP process, then we would ask that the court preserve the National Assembly process and just remit it to the NCOP. We don't have a similar demarcation point in this matter.
Thank you, Ms. Pillay. I just have two quick questions. The one is that there's been a complaint that when submissions were made, the National Assembly failed to apply its mind independently to it, but asked the department for a response. I just want to understand the division of labor between the executive and the legislature. As I understand it, I think Section 84, I could be wrong, says that the national executive develops and implements policy, and the legislature passes legislation in accordance with that policy. But it can't be as clear as that, because the National Assembly is also the common meeting place, as it were, for the public
Yes.
and for the executive. And so while it must discharge its mandate in a manner that's constitutionally compliant, both in respect of the public participation processes, but also the other substantive provisions of the Constitution, it can't pass legislation that's not constitutionally compliant because it's not the maker of policy. But how would you respond to this complaint that when there were valid concerns raised about the bill, it was the duty of the National Assembly not simply to kick the can down the road and say that's a policy question for the minister, but rather to not step into the minister's shoes, but to act as an interlocutor. And did he do that? And if he didn't do that, to what extent would that taint the process? But that means that we need to be clear on what the role of the Assembly is and the role of the Executive is in that space.
Justice Colopin, can I just take 2 steps back in answering the question and start at the point, and I'm going to use loose language to, you'll forgive me. The Executive is the sponsor of the bill. They put, and you can see in this matter, the policy process lasted decades. And the department put together the draft bill. It gets tabled in Parliament. And from the point of tabling, and you can see the remarks made in all of the committee meetings, Parliament says, once it's tabled, it's our process. We engage with the bill, and we will take the process from here onwards. But of course, the executive body is the repository of the knowledge gained over a whole long period, and the investigation, etc. So what happens in this case is that every time Parliament has a public participation event, let's call it that, whether it's calling for written submissions or holding hearings, it then takes that information and asks the department to respond to it, which in the scheme that I've described makes sense, because at the end of the day, the sponsor is the one with the knowledge of the technicality, the detail around what is proposed. What is the defining feature is whether or not Parliament then applies its mind in light of what the department has provided, the information provided, and the responses provided by Parliament. That, I would submit, is what the court should be looking for in assessing whether Parliament applied its mind and ran a fair public participation process. You cannot exclude the department from the process because, like I said, the department is the repository of information and knowledge. What you should be looking for is evidence that after the department has provided responses, that Parliament has applied its mind independently. And you'll find that evidence here. I've already mentioned the 30th of November 2022 meeting. And so my learned friend referred you to the document, which is the thematic report. And what Parliament did there is it drew together themes from all of the public participation hearings and verbatim just condensed it into a document. It provided no analysis because that wasn't the purpose of that document. In the last paragraph of that document, Parliament now asked the department to respond, and we will then consider. And that's exactly what happened. The department then responded to the thematic document. And on the 30th of November 2022, what you see is an active engagement by the Portfolio Committee on what had proceeded, which is the thematic report and the responses by Parliament. And so with respect, that is one example of evidence that Parliament applied its mind independently of the responses of the department. And there's a few others.
Good. And are you saying that provided it applied its mind, if it reached the same outcome as the department did, then it's not a case of simply saying it endorsed the department's conclusions because it applied its mind, but it may just be that it agreed with that.
In all,
And the evidence of its applying its mind can't lie in whether it reached a different conclusion.
And you will find, when you read these reports, there's very robust engagement that happens because these are different political parties within the Portfolio Committee. And that engagement, if ultimately the majority view is in line or endorses the departmental view, then that's just a circumstance, a coincidence rather than design, that Parliament always follows the line of the department.
I suppose finally the Constitution recognizes ultimately, whether we like it or not, that those decisions are taken by a majority vote.
That's correct.
But subject to the right that they must be constitutionally compliant.
And everyone has got the right. Once the decision, the legislative choices made by Parliament is reduced into an act, you can take that act act. You can challenge that act on a constitutional basis. But the reality is that the Constitution endorses decision-making by Parliament on a majority basis.
Ms. Pillay, over here, thank you. Mr. Leach started his discussion by saying that BHF supported universal healthcare and the rollout of universal healthcare, and that it had offered support and resources and so on to your clients, really. And what's troubling in this matter and all the matters that follow it is that there seems to be a lack of engagement or meeting of the minds at any level in a situation where we all know the circumstances in which we live currently with healthcare. And no one needs to be reminded of that. So within that context, it's clear that there's a need for engagement around, what would such a universal healthcare system look like? And what this case is about is obviously how far, what extent of information needs to be provided in order to get everybody on board. And of course, this court hasn't given very tight instructions on what in one case is required versus another. And that's really what we're talking about, is how much information is then required to be provided in a case such as this. And what I think is troubling me is that in a case such as this, where Section 27 rights are obviously implicated and so on, and the nature of the scheme that's intended, which is a far-reaching change to the way in which healthcare would be provided in the country, is there a greater obligation to provide more information at a public participation stage in your mind? Or is it sufficient for the state, or for the Parliament, let's say, in the state, or for the Minister, to simply say, we've made a policy choice, Parliament's implemented it, and no, we're not providing at this stage further information, this is what we've got, we don't know how it's going to look down the line. And whether that's rational or not will be a debate for another day. Is that sufficient, given the extent of the change that's anticipated and that the Act contemplates, and also given the fact that it engages the Section 27 right?
Thank you, Justice Savage. I think there's two parts to the answer. And the first is to emphasize, and it's something that our clients have drilled into us, NHI is about universal health coverage and not universal health care. There's a distinction an important distinction between the two. That's the first thing. The second thing is, at this stage, and I've emphasized this question of legislative design because it was deliberate legislative design. The changes that are sought to be effected through NHI are fundamental changes. It cannot happen overnight. You cannot have a bill being passed today and then implemented from tomorrow. And so the nature of the beast begs for a gradual implementation. And so in answer to your question, at the stage of considering the bill itself, there was simply no option. They gave as much as they could, which went quite far. It was an indicative costing in the green paper. It was sources of funding, etc. I've covered all of that. But certainly going forward at every stage of implementation, whatever, and it's difficult to say definitively, but whatever step is taken is an exercise of public power. And it would be subject to the usual rules, if not administrative action, depending on what we're dealing with. And so you would see that level of accountability and transparency that I sense is underlying your question, Justice Savage, play out in the course of time with the various implementation steps that are taken.
Ms. Pillay?
I'm sorry.
Just one question. During your submissions, you referred to a document. I could be mistaken. I don't know whether you were saying it's the bill or not, where you said that the basket of services are stipulated in that document.
Yes.
Which document is it?
It's the bill. It's Section 57. Justice, sorry, it's very bad, but can I just restate the submission, just for clarity?
Yes.
It's not that the basket of services in its entirety is defined. It's that a particular level of basket of services is defined for a particular group.
Well, I'm sorry to interrupt you, this is where my question was leading. To say that, would you then say that during that public participation process, the public was aware of what kind of services the fund is going to cover or to offer?
I'm saying, as a general proposition, no, the public wasn't aware because the basket of services hasn't been defined. It's quite a nuanced inquiry, and it has to be, you have to give the Benefits Advisory Committee that level of flexibility to determine the basket of services. However, as part of your phased implementation, there is a stage where the Act identifies as an objective the provision of a certain basket of services for a certain group of people. So the Act does take that step of defining, I'm not going to use a minimum level of benefits for obvious reasons, but it's in that kind of light. It's a level of basket of services for a group of vulnerable people.
Should I be concerned or not concerned about the fact that this is a public participation program, and I would think that some of the members of the public are on medical aids, and before they choose the medical aid they want, they actually inquire what services the medical aid offers or what does it cover. And as we know that the intention or the ambition is that the fund covers everybody. So would you say that it was a reasonable process when people were not even aware what they're going to be covered for?
Justice Chief, I think it was a reasonable process. Our submission is it was a reasonable process because part of the legislative design is that there will be implementation progressively, gradually, with an increasing basket of services over a period of time. And because of the nature of a basket of services and what it requires consideration of up-to-the-minute treatment, up-to-the-minute technology. And you cannot have that calcified in statute. And for that reason, it's left the legislative choice that was made. The design is that it leaves that to the Benefits Advisory Committee. The important thing we submit for the purposes of a public participation challenge is that the members of the public were aware that that was the legislative design. It's set out in clear terms. It was dealt with repeatedly by the department. We had explained the thinking behind the legislative design and why it was necessary to go that route, supported by the WHO documents, which support that approach. And so the members of the public, when they engaged with the process, engaged on whether or not that was an appropriate legislative design.
And is it the ambition that whatever is not covered by the NHI, it would be by the fund, it would be covered by medical aids?
Initially.
And at the end of the public participation program, it's not clear, or both to the person who will be covered and to the medical aids, what kind of complementary services would have to come from it?
What we do though is that at some point the minister will make a determination that there is full implementation of NHI. And at that point, medical schemes will only be able to provide complementary cover. But where that point happens is not clear. We accept because of the nature of the beast I've just described, which is there are two main variables in the process. And the one is the time for implementation, at which point of implementation the different steps would be taken. And the second is the basket of services. What services are you going to provide and when?
Thank you. Thank you, Sitchi.
Ms. Pillay, I've raised my difficulties with cost and funding and with basket of services, but I think between you and Mr. Maneche, you've given me lots of food for thought. Now, to deal with this Benefits Advisory Committee, you know, Dawood dealt with what kind of guidance needs to be given to an advisory committee too.
Yes.
So that there's no unbounded discretion without any guidance. One of the things that's said in Dawood at paragraph 54 But before I go there, let me just say this, before I get to Dawood. If you look at Section 25 of the Act, which sets out the powers and duties of the benefits and the method of appointment of the Benefits Advisory Committee. Now, this committee, as you say, will be appointed by the Minister. And bear with me. I'm specifically interested in Section 25.5. I know now, just interrupting myself, that 25.7 says the Minister. Let me take a step back. Forget I said that. Section 25.5 says the Benefits Advisory Committee must determine and review those things: the healthcare service benefits and types of services to be reimbursed at each level of care, primary healthcare facilities and the district, regional and tertiary hospitals, and also the treatment guidelines. And just there, we know that subsection 7 says the Minister must publish these guidelines by notice in the gazettes. Now here's my question. Do you accept that particularly sub 5A, but also 5B, implicates the right to access to healthcare? In other words, what the BAC decides on benefits, healthcare service benefits and types of services to be reimbursed has a direct effect on this right. Do you accept that?
Yes.
Now this is what Dawood says at paragraph 54. And tell me if you say this is not applicable here. Now of course you'll remember that in Dawood it dealt with the extension of a permit. And that power was given to an official. And they say this: we must not lose sight of the fact that the rights enshrined in the Bill of Rights, Section 27 is one of them, must be protected and may not be unjustifiably infringed. It is for the legislature to ensure that when necessary, guidance is provided as to when limitation of rights will be justifiable. It is therefore not ordinarily sufficient for the legislature merely to say that discretionary powers that may be exercised in a manner that could limit rights should be read in a manner consistent with the Constitution in the light of the constitutional obligations placed on such officials to respect the Constitution. Such an approach would often not promote the spirit, purport, and objects of the Bill of Rights. And here's the important part. Guidance will often be required to ensure that the Constitution takes root in the daily practice of governance. Where necessary, such guidance must be given. Guidance can be provided either in the legislation itself, we know it's not here, or where appropriate by legislative requirement that delegated legislation be properly enacted by a competent authority. So, how does this Section 25.5a, how does that comply with the Dawood test?
Justice Majid, on two bases. The first is that one must appreciate the context and special features of this particular piece of legislation. It operates in a health environment, and why there's a need for that level of flexibility for the Benefits Advisory Committee. And we're saying that that may be a distinguishing factor from Dawood, and I'm aware of the Dawood principle. But secondly, if one is engaging in a debate on Dawood, Justice Majid, then we're engaging in a frontal attack on the rationality of the Act. And that is not the debate for today. All this court has to decide is whether or not the public participation process followed was reasonable. And we say that it was reasonable because the legislative design was engaged upon, the public had an opportunity to raise their concerns, which may have also included that it falls foul of the Dawood principle. But ultimately, Parliament decided.
Well, let's debate that. You see, you're bringing a bill, just switch off your mic there, the transcribers have asked that we do so. Thank you. You have a bill here that radically overhauls the health system. In fact, the President, I think, called it a revolutionary enactment, which it is. And again, I say it's what we should strive for, universal health coverage, not care. And the public is being asked to entrust this process of a possible implication of their right to access to healthcare to a body, the BAC, with unguided discretion, unconstrained discretion. That's how I see it. Please show me where I'm wrong. And it then leaves it. There's only one constraint. There's only one constraint is in 25.7. The guidelines that you must consider for cost-effective and detailed treatment guidelines is left to the minister. Parliament has no say in all of this. And so then this public is asked, whether it be the user of the Baragwanath Hospital or the big medical aid scheme, Discovery or whoever else, you are being asked to comment on this bill to say that these, as you say, may well be rationality challenges, but we can't tell you more than this, that this body will make these crucial decisions. Surely there should be an indication of how these powers will be constrained, what guidelines will be implemented, and so on. I am not persuaded that it's good enough to say, well, that's really a rationality challenge. Because rationality will come into it in a sense, not as a separate self-standing challenge, but as a challenge to say, we can't meaningfully, and I emphasize that word, we can't meaningfully comment on a bill which leaves everything like up in the air, which leaves everything to say, wait for it, it's going to come. So that's my concern.
Justice Majid, as I understand Dawood, the passing of regulations to provide guidance on the exercise of the discretion is permissible. And that's specifically what the Act envisages. And our difficulty...
Say, as long as it's not venture into the terrain of plenary lawmaking.
Absolutely. And what we're being asked to do is to speculate on what those regulations will look like and to comment on the rationality of the scheme when it's not complete. And that's the difficulty with the engagement. And it's for that specific reason why this court has set a different standard for inquiring into the legality of a public participation process. And that standard is mere reasonableness. Now, we would submit that when you consider that reasonableness, you must consider the special features of what is being dealt with here. And the department has explained it over and over. And without wanting to step out of, because we make the argument in the papers around the need for flexibility for the Benefits Advisory Committee. Things on the ground in the health space develop on a daily basis. The Benefits Advisory Committee needs to be able to cope with that change. And you cannot tie the hands of the Benefits Advisory Committee and allow them, and not allow them to go with the change, with the flow. And that's what's been explained as the reason for this. We would submit that if we are faced with a rationality challenge, hopefully by then we can have regulations which will fill in the gaps, and if not, we'll deal with that case at that point.
I don't want to go into the detail, but if one looks at international comparative legislation, the US, the UK, I think Australia, Canada, except Taiwan, as far as I could see, what they do is they put the benefits, the basket of service, the cost of funding generally in the primary legislation. And they don't leave it to a body like the DAC. I'm not saying they have bodies like that. Now, when it comes to regulation, surely we are in a position, and I'm just testing that. I don't want to go into the detail. That's a long question, but are we permitted, just as a matter of principle, as a third world developing country, to have regard to first world developed countries with rich resources when it comes to regulation? Not about what should be given to the health care users, but to regulation. Is there anything wrong in saying let's compare ourselves to countries elsewhere in the first world as opposed to the third world?
Justice Majid, unfortunately on the papers I don't have sufficient knowledge to interact with what's happening in other developed countries. I can say that what the department has indicated extends over and over again in the public participation process is it's following the guidance of the WHO and completely falling within the ambit of what the WHO says should be the correct approach, that you can't cost too far in the future for a number of reasons, including the fact that there are massive inefficiencies which you are trying to undo through NHI, which you will incorporate if you were to cost now using that costing information at your disposal. Also, just to... I'm sorry, and then the prolonged period, the WHO says you cannot cost over a prolonged period for obvious reasons. Things are changing every day. You're going to end up with a costing exercise that's irrelevant because there's been a change. Even a slight change in the costing structure has massive ramifications because you're dealing with economies of scale. And so, in answer to your question, what the department has done is that it has remained faithful to the guidance of the WHO.
Thank you, Chief Justice.
Ms. Pillay?
Immediately to the court, Chief Justice.
There is a straggler question for you, Ms. Pillay, sorry. You're not off the hook just yet.
There's something that I want to clarify. It arose during a question by one of my colleagues about, it related actually to the remedy. And I want to know if I heard you correctly that while you were postulating a response on the remedy, you alluded to the fact that if in the case of the Premier in the Western Cape, the position might be different in the sense that we would have to look at the position of the NCOP. Did I hear you correctly there?
That's correct. The challenge is directed solely at the process of the NCOP. And so a discussion on remedy in that case would be easier because we would ask the court to lean in favor of protecting the NA process. And I know it's not consistent with which is...
Because that worried me to
Yes.
say, in the Western Cape, this would be the remedy. But in this national legislation, you would be advocating for something different. Maybe I don't understand.
I'm sorry, Justice Matopo, I think it's probably my fault for not articulating it clearly enough. What I meant is in the Western Cape challenge tomorrow, because it's only directed at the NCOP process, if the court upholds the Western Cape's complaints and finds that the NCOP failed to put in place a reasonable public participation process, in our heads of arguments, and tomorrow we'll do the same, as part of the remedy, we would ask the court to lean in favor of protecting the NA process and just remitting it back to the NCOP. And that's because of the nature of that attack. It's only directed at the NCOP.
I just wanted to know whether that is practically possible.
We submit that it is, and it's a debate we'll be happy to raise tomorrow. But we would submit that...
In fact, that's what I was going to ask, if it might not be wise to leave that question for tomorrow's debate.
All right.
But you seem willing to...
Let's cross that bridge when we get to it.
We will do. Thank you, Justice Matopo.
Yeah. All right. Thank you, Mr. Pillay. Mr. Steyn, anything to say? Oh, there is.
Chief Justice, can I have an hour? Chief Justice, I'll be brief, and I'm mindful of your admonition. Chief Justice, members of the court, as you're aware, the President doesn't enter into the fray on the merits of this matter. I think it's a courtesy to the court to explain why, and there's good reasons for this. This is a challenge to the parliamentary process. There are separate challenges, including one brought by this very applicant, to the presidential assent under Section 79, and those are presently pending before the court. The President's primary concern, and I think it's one that's been followed in the submission of oral representations, is to ensure that extraneous issues that on a proper consideration apply to the matters that are pending before the court do not intrude upon the court's consideration of this matter. And it's for that reason that we drew the court's attention to a number of these. And I'm not going to take the court to those particular ones, but there are a series of them set out in the President's affidavit and in the heads of argument. To deal with them thematically, one of them was the allegation of an electioneering motive on the part of both the President and Parliament and other representatives. The second was that the President ignored the BHF's representations that the bill was unconstitutional. The third type of this kind of allegation in the affidavits was that the President did not address concerns or provides reasons for the assent or assented, in the words of the affidavit, without demur. Now, the members of the court will readily appreciate that those are allegations that are extraneous to the present proceedings, and in this regard, I'd like to make just two brief submissions. The first of these submissions is that, as I think it was Justice Majid observed, allegations of political motivation, loose allegations of ulterior purpose by Parliament or the President in this case, don't advance the challenge. In this case, the issue is whether Parliament's public participation process was constitutionally compliant under Section 59 or Section 72, depending on which representative body one is dealing with. In particular, the considerations relevant to the President's assented signature are logically and legally irrelevant to this Court's consideration of that parliamentary process. That's the first submission. The second submission is that in any event, and a number of parties have referred to this Court has held that the motives of the particular bodies and representatives are irrelevant to the inquiry and simply cloud the issue. And that finding was in the Poverty Alleviation Network case, and if I can refer the Court to the paragraph, it is paragraph 73. That was in the context of a rationality assessment, but we would submit that the principle is equally applicable here, that the motives involved, particularly in the context of a, by definition, politically complex process, are irrelevant to the Court's consideration of whether, objectively speaking, the parliamentary process complied, was constitutionally compliant. So we asked the Court, and I think it was implicitly accepted because it wasn't referred to in the oral submissions, although it is in the papers, that the Court disregard those allegations where they appear in the founding affidavit. Finally, I make one general submission, and in some respects it's going to be defiant of you, Chief Justice, but I think it bears reiteration because it has been alluded to and referred to by my learned friends. It's important to impress upon the Court the scope and significance of NHI. The NHI Act is the beginning of the fulfillment of a promise that is contained in the Constitution and that was made by a succession of democratically elected governments. That promise, as the President says in his affidavit, is to bring equal access to health services to all South Africa's people. This is an immense and ambitious project. There's no place in that. There is a place for a number of well-founded challenges. Whether they are meritorious or not will be decided by the Court. But there's no place for unfounded cynicism or loose accusations of ulterior purpose in that regard. The democratically elected representatives carry an overwhelming mandate to achieve the goal. And it's fair to say, I think, on the evidence that they apply themselves diligently and seriously to the task. Whether they've erred constitutionally or not doesn't mean that they have that they're deserving of some sort of accusation of bad faith or otherwise. So that is the general submission that I ask govern the Court in its consideration of the matter. We do so on behalf of the President. Chief Justice, that is the limit of my submissions.
Thank you. Thank you, Mr. Stein. Mr. Leach, how long is your... Oh, sorry, Mr. Papania. How long is your reply going to be?
As much time as I can possibly get. I did, after all, just get off from the bus. Thank you. Chief Justice, members of the Court, the high watermark of both Parliament's as well as the Department's argument is details later. But that argument of details later is weak when one takes into account the context, and everybody has spoken about context, but when one takes into account the context of this legislation that came into being. Let me start with the following, and this would, of course, feed into my submissions or my reply insofar as the absence of information is concerned. When one looks at the context of this matter, what we shouldn't forget is that the historic documents present the appropriate context. When the NHI bill was introduced on 7th of August 2019, members of the Portfolio Committee had, and it's been said already in the founding submissions, among other things, the Green Paper, the Socio-Economic Impact Assessments, and the White Paper in respect of the bill. But what hasn't been emphasized is that those documents themselves record that a number of structural concerns required consideration. Because of the limited time that I have, I'm going to pass on references. The Green Paper, by way of example, paragraph 114, page 003-570, tells you that the precise combination of the various sources of funding is the subject of continuing technical work, and what did the department promise then? It says that it will further be clarified in the next 6 months. Paragraph 118, page 003-571. In respect of the issue of how much NHI will cost, it says that it is not possible to model with 100% accuracy figures presented, but the figures presented provide a good indication. And those preliminary estimates, they said, were an iterative process, and they promised that further work will be undertaken to refine cost estimates. The estimates themselves, which 119, utilize a costing model. What these documents contextually demonstrate is that from the outset, Parliament was alerted to the significant concerns regarding the disability and the constitutional scheme. Those same concerns were repeatedly raised during the public participation process by stakeholders from different sectors of society. And that should have punctuated the need for meaningful engagement by Parliament. But the evidence placed before this court does not show that these concerns were meaningfully engaged with, even though they were identified in the beginning, reiterated during the hearings, and persisted with throughout the legislative process. And that is the important context. But more troubling, and let me come to the substance of now obligations. Here's another contextual factor. Rule 2791C, Roman numeral 2, of the National Assembly's rules, they provide a positive obligation for something to happen, and that is for an account of the financial implications of the bill for the state. That's a positive obligation. Parliament and the department say that they've complied with this obligation, and what they do is that they provide the accompanying memorandum, which appears on page 003-832. Parliament in particular refers to paragraph 8 on page 003-843. But I've heard concerns from various members of the court as to whether that paragraph says anything to anyone. On our reading of it, paragraph 8 is undecipherable at best. An account, at the very least, requires an indicative amount, not a precise amount, an estimate of an amount, which will tell you the amount for which the state may be implicated for and how that amount is arrived at. And we have no difficulty if that amount had to be an estimate, and we have no difficulty if that amount had to be articulated on assumptions in respect of which the public could then meaningfully engage with. But a mere reading of paragraph 8 of that accompanying memorandum does none of that. Ultimately, there is no estimate, no indication on the projected costs of the scheme, the services to be funded, the anticipated utilization of those services, matters that had been guesstimated in the Green Paper. And significantly, there's also no indication on the source or the scale of funding. Justice Rogers, you asked the question about the distinction between the availability of information and the existence of information. And this is where, once again, what the BHF does not ask for is for a judgment to be written out on what Parliament's obligations would be in all cases. But it's important for a judgment to be written out on what Parliament's obligations were in respect of this case. And Parliament's obligations in respect of this case starts from the textual obligation of Rule 2791C2. The Green Paper anticipated further defined costing. The White Paper, which also engaged with anticipated costing. But what one's got to bear in mind is that that information was reasonably required because when the bill reached Parliament, the issue was deferred rather than answered. And so that is the most damaging part of the framing by Parliament and the Department, that details can come at a later stage. It's effectively like saying, come over to my dinner party and I'm going to give you bones. Nobody is going to be filled with bones, unfortunately. If I can then deal very quickly with the Armstrong report. Our learned friend for Parliament says, have a look at what Armstrong says at page 003-350, paragraph 222, all the way to 226. What Dr. Armstrong says at paragraph 222, in short script, is that you can arrive at estimates, but they require assumptions. But tellingly, at paragraph 226, Dr. Armstrong says that proceeding without an indication of resource requirements is highly problematic. I'll learn then if I can deal with the aspect where they said, but we did not need that information because we had Dr. Armstrong, from which Dr. Armstrong extrapolated data going all the way back from 2010. And for that reason, Parliament is absolved from providing meaningful information. That principle was decried in Corruption Watch at paragraph 60, for your references. Insofar as Treasury's input is concerned, the best that we have seen, which was referred to, is Annexure AA7, the thematic report. And what one notices over there is that on page 004-684, paragraph 4.2, it says, the majority were of the opinion that owing to competing demands on government's already constrained budget, South Africa lacks fiscal space to adequately fund the NHI without jeopardizing the financial position of the country or the stability of the economy. And it sets out what the minister is quoted as having indicated. The Minister of Finance is quoted as having indicated that the NHI is unaffordable considering South Africa's current debt level, and it does similarly in respect of the Davis Tax Commission. Moving on to the desirability or the request for a further revised feasibility study to be conducted. What the department has said is that that was unnecessary, and it says it was unnecessary simply because you have they said simply because it would take 25 years for the project to stabilize. They also say that it is clear from section 57.1 that the act will be implemented in 2 phases. What one's got to bear in mind when one takes into account section 57.1, it does not talk about a 25-year period for the stability of the NHI scheme. It talks about 2 phases that goes to a period of 7 years. And that's in the latest act. It talks about a period from 2023 to 2026, and then from 2026 to 2028. Now, when one takes into account that short period of time within which both phases have got to be implemented, there is an immediate need for purposes of projecting the costs of the scheme and the manner in which it could potentially be sourced. If I can then turn over to the basket of services. The basket of...
No indulgences this time, it is reply after all.
Mine is very short, just the reference. You referenced the green paper which cautioned about affordability and costing. Is there any reference you can give me in the white paper that says something similar, or isn't there?
No, so the white paper does not say anything similar. Our learned friend Ms. Pillay had taken you, Justice Majid, to section 7 of the white paper, It deals with a number of subparagraphs, and they decided that they were going to deal with high-level issues rather than following what had been encountered in the Green Paper.
Confirm this paragraph 4.2, which raises concerns about affordability, where the minister says NHI is unaffordable. Am I right that this is a summary of public submissions on the NHI compiled by the National Assembly?
That's indeed correct.
Okay, thank you. Chief Justice.
Thank you, Mr. Babamia. I just have one question. The questions of affordability, surely there are two options. The one is government will source funds in a manner that's constitutionally compliant and permissible. On the other hand, it may seek to source funds that are in many ways impermissible constitutionally. That's not giving a blank check at this point. It's open to challenge how that occurs, just as it is open to challenge if a basket of services makes inroads into existing rights or doesn't cover contingent rights adequately. All I'm saying is that there is uncertainty going forward, and we've heard arguments with regard to why certainty and precision may not be possible. The guidance from the World Health Organization and the experts may differ. But it doesn't mean that if one chooses one option and not the other, that is necessarily offensive. So what I'm putting to you is that it's not as if the approval by Parliament of the bill then sort of deploys it into uncharted and unknown waters. Our Constitution has sufficient checks and balances, and in particular, the notion that all constitutional power must be lawfully exercised is a considerable restraint on the manner in which power may be exercised in the future. So it's not as if the public will be at the mercy of the minister, of the DG, or whoever, functionaries, because we live in a constitutional state.
Justice Colopin, with the greatest of respect, it would be putting the public into uncharted waters. It is providing a blank check to the regulators of this legislation, or the administrators of this legislation. And the reason I say that is there is an antecedent question before you even go to the uncharted water issue. As everybody has said, this case is about meaningful public participation. But can you be said to have had meaningful public participation in circumstances when you don't know, not even as a matter of an indication, not even as a matter of provisionality, as to where you're going to get that type of funding from? When you don't know, as a citizen of this country, what rights, other socioeconomic rights, you may have to give up on for purposes of this particular piece of legislation, which is in its trial stage. That is what renders the public participation meaningless. Circumstances where you don't know how you can evaluate between the number of competing rights that you have for purposes of which you may have to give up one over the other so that you can advance the NHI scheme.
I hear you, and I don't want to continue the debate because it's late in the day. But on that scenario, we will never be in a position of certainty with regard to the choices we have to make at the level of policy, as a matter of law, as a matter of program. Yeah.
Do you wish for me to comment on that, Justice?
Not unless it's something that's going to make me not regret asking the question.
That will ultimately be for you to decide as to whether there are regrets or not. But you raise an important point about the advancement of legislation, and we won't go anywhere if, we don't sometimes take these shots in the dark. But one's got to make an appropriate balance. This is about constitutional discipline. Of course, we're not asking for precision to be exacted, but we are asking for there to be some level of discipline so that there can be meaningful participatory democracy that is contemplated by the public participation obligations.
I'll leave it at that. Thank you, Mr. Babamia.
Thank you very much, Mr. Papamia, everyone. The proceedings will resume tomorrow at 10 a.m. with the Premier's case 6269 of 2025. Court adjourns.